set made in Japan.
Okay, to our first guest, could you briefly explain what monism means and the reasonable argument to justify your application or pleading behind it?
Okay, thank you, Aina. Okay, from the monist perspective, international law and domestic law are not two different systems. They are one unified legal system. For example, this means that when a country accepts an international treaty or obligation, those rules can be applied directly within the country or needing additional domestic legislation. Personally, this theory it creates consistency and efficiency. In today's globalized world, many issues such as human rights, climate change, international law, and migration go beyond national borders. If every country has to go through lengthy legislative processes before applying international law, important protection and obligations could be delayed.
Thank you, Ms. Atira, as our first speaker. Now let us hear the opposing perspective. Let us welcome Ms. Aina Rashid as our second speaker. Let's welcome Ms. Aina Rashid as our second speaker. Aina, how does dualism differ from monism?
So, if monism theory they focus on the international law and domestic law being in one unified legal system, dualism is the exact opposite of that, which is international law and domestic law being two separate fields of law. So, if again in monism they say that the international law and domestic law they come from the same highest source of validity, which is the ground norm, and that international law is superior than the domestic law. So in dualism, international law is not superior to domestic law, and that they function differently unless the international law is being approved to be used in the domestic legislative parts. As I said just now, that the international law is only applicable in the domestic law if the parliament, let's say for Malaysia, if the parliament has approved international law being constituted in the domestic law. That means the international law is only effective when it's approved. And according to Heinrich Trippel, one of the most prominent proponents in the dualist theory, he said that international law handles the interstate relations, while domestic law, as the name itself, domestic, it handles the in-state relations. So that's how the dualist theory, the dualism, differs from monism.
Thank you, Ms. Aina, as our second speaker. Now, moving on to the third speaker. Some scholars argue that international law should automatically apply within the domestic courts. What do you think of their approaches and theories influencing contemporary international law as of today?
Thank you, Ain, for the question. Like Tira said before, that monism holds that international law is superior and can apply directly in domestic courts, especially in human rights cases. This ensures a better protection and prevents state from avoiding obligation. So scholars like Hans Carlson and Herschel Lodepetz influenced this idea by emphasizing a unified legal system and individual rights. So, however, in practice, not all states fully apply monism due to different legal systems.
Moving on to the third point on national sovereignty. Please advocate your theory approach regarding the national sovereignty while ensuring compliance with international obligations.
Well, thank you, Ms. Ain. In my opinion, monism provides a better balance between national sovereignty and international responsibility. Some people argue that monism reduces state sovereignty because international law can apply directly within a country. However, I would argue that sovereignty is actually respected because states voluntarily choose to join treaties and international agreements. When a state ratifies a treaty, it is exercising its sovereign power. Therefore, complying with that treaty is not a loss of sovereignty, but rather a fulfillment of a commitment that the state willingly accepted.
Thank you, Ms. Tira, for your insightful view on monism perspective. Moving on to the dualist approach. What is your say on this, Ms. Aina?
So for me, the answer is already in the question itself. Protecting national sovereignty while ensuring compliance with international obligations. So as we know, dualism, they separate the two fields, international law and domestic law. So in dualist approach, it highlights the sovereignty of a nation's legal system by ensuring that the international commitments, international obligation does not interfere with the domestic law unless the legislature agrees. So from that, we can say that the debates for approval can cause delays and conflicts between international expectations and domestic enforcement, especially if the political will to implement is lacking. So I think that always has been the case for any country. There's always been conflicts and delays. However, in Malaysian court, it may apply the international law to the domestic law if it's consistent with the existing domestic law, and then only selected provisions of the treaties consolidated and incorporated into the Malaysian laws, such as the United Nations Conventions on the Rights of the Child, CRC.
Thank you, Ms. Aina, for your insightful view on dualist approach. Moving on to Ms. Putri, you may now advocate the opposing view of dualism.
So basically, monism is the idea that international law and domestic law are not separate systems. Instead, they are the part of the single legal system, and more importantly, under this theory, international law is considered superior to domestic law. So what does it mean in this practice? Mean that if have a conflict between international law and domestic law, the international law should come first. So now, one of the main reasons people support this idea is because of global consistency. We live in a world where countries are connected with each other, so we need to common set of the rules. If every country just follow its own laws and ignore international law, things can become very chaotic. So another important point is that the country cannot use the domestic law as an excuse to avoid the international obligation. So if a country has agreed to a treaty, it cannot later say, oh, our national doesn't allow this. It's just escape the responsibility.
So we have come to the end of the first episode of Group Podcast. For me, I personally agree with the dualist approach, highlighting the sovereignty of a nation legal system by ensuring the international obligation will not interfere with domestic law unless proven otherwise. As for our viewers, it is up to your insight whether to agree with monism or dualism. Let us know and drop your opinions in the comment section down below. That is for today. You can stay tuned for our upcoming video from our fellow groupmates as well. See you. Bye.
Bye bye.